Yeah, good morning to everybody. Sorry that we are a little bit late, but I have to tell you, you have a very vibrant civil society in this country. We were going a little bit over the time, but that of course speaks for the human rights culture in Taiwan. We are a little late, but I think if we try to stick to the points, we will manage today. Our plan is that we start with the list of issue number 27, where we stopped yesterday, so still under Article 7 and 10, then take up 8, 9 and 11, but then move directly to 14, 15 and 16, for two reasons. On the one hand, the right to personal liberty and fair trial due process are closely related. And the second reason is also that the person who is primarily in charge, Professor Cohen, for this cluster, Article 14 and following, will unfortunately have to leave in the afternoon. So that is what we should in any case cover in the morning. If we are also able still to take up 12, 13, so better. If not, then we would deal with 12, 13 plus 17 to 25 in the afternoon. We will manage to do that. So if we go back to 27, still in relation to Article 7, there was the question of non-refoulement, and the State report has admitted that there are no adequate laws implementing the principle of non-refoulement in relation to Article 7. In the government replies, you said there have not been any relevant cases about foreigners being deported out of the country to any other countries which might have cruel torture up to now, which is also acknowledged by the NGO replies. But still the question remains whether there are any plans to draft non-refoulement procedural rules in a specific law or in relation to the refugee law. So my question is, where do we stand, and are there any legislative proposals in this respect? So it's a question relating to Article 7, to some extent also Article 12 or 13 in relation to refugees. Who would like to take up this question?
The immigration agency. I am the Deputy Director General of the Immigration Agency. In response to your question, we do have two proposals at this moment. First of all, we would like to enact the Refugee Act, which has been submitted by the Executive Yuan to the Legislative Yuan, which also includes the non-refoulement. Moreover, we have revised the Cross-Strait Act in relation to the nationals of the PRC, which is being reviewed by the Legislative Yuan. And right now, we have some cases involving PRC nationals whom we would like to deport to the third country, but no country would like to take them. And we give these people 20,000 New Taiwan dollar every day for living allowance. Every month.
Any questions from my colleagues? Please.
Some years ago, I had the opportunity to visit some of your detention cells, and they were filled with women from mainland China who had not been repatriated or sent back. Do you have any sense, has that problem been improved in recent years? How many women would be detained now? For how long? I was very affected by their plight. They just seemed to be sitting in prison cells, waiting day after day, doing nothing, very demoralizing. And could you bring us up to date on that problem, please?
Right now, at these shelters, only 8 of these people there are from mainland China. The mainland China would have them picked up back to mainland China 3 times a year, especially during important festivals like the Dragon Boat Festival. In other words, they would have a vessel sent to Taiwan to pick up these people. The vessel cannot accommodate as many as 150 people. The length of the detention is 4 months, the maximum. In fact, for all aliens in these shelters or detention centers, the maximum length of detention is 4 months. Usually it's 2 months with an extension of another 2 months. For the PRC nationals, we have revised the Article 18 of the Cross-Strait Act, which is being reviewed by the Legislative Yuan. So we are taking proactive action to address human rights issues, regardless of the origin of country these people come from.
Thank you.
But do we agree that the 120 days limit is not applicable to mainland Chinese? So there you are only, so presently it's still unlimited detention according to the law. But I have taken it that there are legislative proposals to change it.
Please allow me to clarify. According to the existing law, there are provisions saying that the aliens can be detained in these shelters for no longer than 4 months. There are no such specific provisions in relation to PRC nationals, but in practice, we treat them as equals.
To come back to that under Article 13. Now I am coming to list of issues number 29, because 28 we dealt already yesterday, the corporal punishment in schools. 29 relates to the medical treatment of detainees, and we have read that now the national health insurance is applicable on an equal basis also to detainees. In the NGO report, there is another proposal or recommendation that the competent authority concerning the inmates' health and medical treatments should be changed to the Department of Health. And in my experience as UN Special Rapporteur on Torture, that was one of my main recommendations to all countries, that the health system in prisons is improving if the responsibility is transferred from the Ministry of Justice or Interior to the Department of Health. So could we have a response to this particular recommendation? Are there any plans to transfer the responsibility to the Health Department?
Good morning. In terms of the national health insurance, starting this year, the 1st of January this year, all prisoners are covered by the national health insurance. I believe this is an important milestone in the history of prison management. In the past, we did not have sufficient medical resources, so we could only rely on the services of specially appointed physicians to provide medical services for prisoners. But now things have changed. All local hospitals and clinics have signed agreement with local prisons. Every day, physicians will be sent to the prison to provide medical services. I believe this is great news to the inmates. Moreover, the medical equipment, including the X-ray machine and other basic testing equipment, will also be provided by hospitals at the prisons. As a result, the inmate does not have to leave the prison to receive medical services in external hospitals. If the inmate falls ill, we also provide appropriate arrangements. For example, we do have professional ward for these sick inmates in the Taichung prison. And for some seriously ill inmates, we also have the mechanism to help them to receive medical services outside the prison. In addition, we also pay close attention to the health of the inmate. So at all correctional institutions, we will work our best to improve the health standards and services available to prisoners. In terms of the environment, we would clean up the environment, sterilize the environment to make sure there's a sanitary prison environment. As for public health education, local hospitals will help provide such training and information. So in the future, we will keep working in this regard. Thank you.
Thank you very much for your explanations, but you did not address my question. The question is very simple. On paragraph 78, you said, based on the provisions of Prison Act and Detention Act, the Ministry of Justice have rights and responsibilities to prisons and detainees' health and medical treatment. NGOs, and I would add myself to this, would propose, in order to further improve the medical treatment of prisoners, to transfer the responsibility from the Ministry of Justice to the Health Department. Of course, there is no obligation whatsoever. I just wanted to bring that to your attention and ask whether there are any plans in this direction.
Thank you for raising this issue. I think if the Department of Health can oversee the medical issues in correctional institutions, that will be great. We actually look forward to that kind of arrangement because it can provide even greater protection of the health of the prisoners. I think this really touches upon the issue of different responsibilities of different government agencies. In prisons, we ban and prohibit torture and inhumane treatment. So even though the MOJ is in charge of this matter right now, but we are not providing the medical services ourselves. Instead, we commission the hospitals and clinics to provide these services. In other words, these hospitals and clinics are subject to the oversight of the DOH. But I guess there may be some difficulties for the DOH to be the direct overseer of the matter. So I think the MOH may have the public hospitals to be more directly involved in this matter.
The Ministry of Justice would agree. Is there a representative of the Department of Health present today? Then we could have a direct reaction. If not, I take it that you will discuss this within the executive yuan, whether there would be a willingness to take this responsibility. As I said, countries that have done it have had a very positive experience by improving the health treatment of detainees. We stay with the prison conditions, and number 30, I think everybody agrees that there is overcrowding of prisons. The response to our list, or question number 30, first of all, in terms of statistics, there is a difference. The government reported, and I just wanted to clarify that, the government reports that by January 2013, the total inmate population of correctional facilities reached 54,593 inmates, and that exceeds the capacity by 10,000. So 54, and in the reply from the Taiwan Action for Prison Reform, they said by the end of 2012, the number of inmates was 66,106. That means 12,000 higher, of which 29,000 were sentenced by drug offended. Could we clarify which of the two statistics is correct, please?
The numbers you hear were provided earlier, so I can say that currently the number of total inmates is 64,399. Our capacity is 45,000, and our male inmates reach 58,000, while female inmates are 5,000. And the overcrowding rate is 17.98%. So the current number is lower than the number we provided earlier. Now, speaking of overcrowding in prisons and detention centers, the government has already devised some policies to respond to this need. Our short-term goal is to use deferred prosecution or labor or transfer to reduce the number of new inmates. Secondly, we want to use the mechanism of parole, so people with misdemeanor or people who meet the standards of parole can leave the prisons as early as possible. And thirdly, we want to use more effectively the space of current prisons. And fourthly, for prisons with low security risk, we accommodate multiple of them in the same cell so that we can accommodate more prisoners in general for a certain facility. Indeed, overcrowding is an issue that requires multiple measures. So we will use relocation, expansion, or reconstructing project to expand the capacity of the prisoners. But of course, at the same time, we need to consider the financial pressure on the government, and therefore we will prioritize these projects to decide which project should go forward first. Which project of relocation, expansion, or reconstruction should go first. And home arrest or using electronic monitors on the prisoners can also be applied to solve this problem. We know that in other countries, for example, in Germany, in their criminal code, it stipulates that they have their mechanisms in order to make effective use of the capacity of their detention centers and correctional facilities. But all in all, I can say that we have some positive measures right now. We are now in the process of expanding the Taichung prison for female. And we are also expanding the Taipei prison. Both of these projects have been approved by the Executive Yuan, and we are moving very aggressively in improving these prisons. We're also having some improvement project for the Yilan prison. And for detention centers in Taoyuan and Hsinchu, there are plans to relocate these facilities. Within 10 years, we hope to totally review and resolve the problem of overcrowding in prison. To achieve all these projects, we have more than 15 billion NT dollars. And again, as I said, these projects will be prioritized. If all projects go smoothly, then we can expand the capacity by 14,000. I believe these will relieve the current overcrowding problem in our prisons.
Much. I take it first that the actual figures in the reply of the government are not correct. So what I understood, it's presently about 64,000, so it's close to the number provided by the NGOs. If you could give us a precise statistics on the current situation in writing, I would be very grateful, and perhaps also indicating the percentage of pre-trial detainees among all prisoners. On the policies of how to reduce prison overcrowding, of course, in principle, there are two different types of approaches. If one has such a problem of overcrowding, you can build new prisons. That's one approach. and you can try to reduce the number of prisoners. From a human rights perspective, we always try to apply the second approach, which doesn't take away that sometimes it is necessary to also build a new prison or renovate old prisons. I was a little bit struck by the very high amount of money that is planned to complete, so for the construction plans as outlined in paragraph 80 of your report. Now, if you take the approach of the non-governmental community, then what they are saying is about almost half of all inmates. They say 29,000 out of 66,000 are sentenced for drug-related offenses. And therefore, their proposal would be, and I read out, in order to solve the problems of prison overcrowding, the government should reform the policy of anti-drug, reduce the inmate population in prisons, and decriminalize the drug use, leaving the monitoring and treatment of drug users to social welfare systems, medical institutions, and the National Police Agency. Again, of course, the criminal policy of a country is in principle, of course, a question of domestic jurisdiction. It's your decision. But since it seems that a very, very high percentage of prisoners relates to drug offenses, and there is a fairly strict drug criminal law approach towards the drug problem, I would just like to raise the question whether there are also certain plans to revise the drug policy and by that reduce the number of prisoners. Of course, we have also taken note of what you said and wrote, that you might also reduce the number of prisoners by means of home arrest, parole, electronic shackles, etc. But perhaps somebody could say a word on whether there is a willingness to approach also the drug policy.
这个毒品政策的部分呢，我们
As for drug policies, we do have a Drug Use Prevention Act. So there are 4 levels of drug users. Only the offenders who are at the first level, which are the most serious, will face criminal charges or penal punishment. For example, the MOJ has a review panel to decide which type of drug use constitutes level 1 or level 2 or level 3 or level 4 offense. But the most serious level, level 1, will face penal punishment. But maybe another delegate can talk more about our anti-drug policies. Our national anti-drug policies can be separated into 4 aspects. The first aspect is prevention, and the second is education, the third is abstention, and the fourth is dropping drug usage. So the government want the drug users to participate in abstention or rehabilitation project. We also use education program to discourage our nationals from using drugs, whereas our prosecutors work very hard on a monthly basis to fight against drug use. So even though there's a huge number of drug offenders in our prison. The total number of drug users in Taiwan is decreasing. So the number of drug users is decreasing, but there are also some offenders who sell drugs, and they are also put behind the bars, and that's why there seems to be a high number of drug offenders in the prison. But in fact, the number of drug users is decreasing, and only repeated offenders of drug uses will be treated as criminals. For first-time offender, we treat them like patients. We put them in the shelters, and we include them in rehabilitation centers. So in our correctional system, we have rehabilitation centers which treat first-time offenders as patients and not criminals. I would like to supplement. The numbers that we provided were not wrong numbers. It is just that numbers change and numbers are updated every day. Per your request to submit the latest numbers and the percentage of pre-trial prisoners will be submitted you in written form later.
In fact, in recent years, the prosecutor's officers have begun using the suspended prosecution approach, so that most of these drug users have a chance to receive rehabilitation. So the prosecutor does not indict these drug users right away. Instead, these people will be referred to hospitals for rehabilitation unless this person refused to cease and quit on drug. He or she will be sent to a particular rehabilitation facility.
For this promising information, and I would be happy if in the statistics that you will provide us, perhaps you could also indicate the percentage of drug-related offenses, and perhaps over the last 3 or 5 years, whether there was also a change, a decrease or increase. Thank you very much for providing this information. Asma.
I mean, the question of overcrowding is an epidemic, I think, in this part of the world. In my country, for example, most of the overcrowding was pre-conviction prisoners. And so we had a law where if the trial did not conclude within 1 year or 2 years, then people got mandatory bail. So that helped a lot. Then that provision finished, and now we have again enormous overcrowding. So I was wondering if there is something like that. I know that I've seen that you have probation here as well. How much of it is, how many prisoners and what categories do get probation, are out on probation, but do you have something called statutory bail if the trial continues for years and years?
Receive this information in writing when you provide us about the prison statistics. But you raised already pre-trial detention, and that brings us to the next issue, question 31. And there I was...
Before we leave, are we going to come back to the question of prison conditions, or is this the time to mention that? In addition to overcrowding, you have other questions that relate to overcrowding, like abominable conditions in prison cells.
We are still in the prison conditions, so we can then take it up. Under Article, also question 31 relates to the Detention Act and to the difference between pre-trial detention and detention after conviction. And I was a little struck by the explanation in paragraph 81 where you speak about the fact that pre-trial detainees have more rights than convicted prisoners, and then indicating, so I read out one sentence, moreover, the detained defendant, so the pre-trial detainee, has entitlements not available to incarcerated convicts, such as the civil rights, political, economic rights, right to use cultural resources, right for personality development, information rights, privacy rights, right to uphold reputation, freedom of religion, and other basic human rights entitlement of an ordinary citizen. Now, if I take this, then you are saying more or less incarcerated prisoners have no human rights at all, which of course is not in accordance with international human rights standards. Prisoners should enjoy all other human rights also in prisons to the extent that this is possible in a closed environment. So of course they don't enjoy the right to personal liberty or freedom of movement, and they can go to demonstrate. But all the other rights, in particular what you were here citing, information rights, economic rights, that they should have a right to work, for instance, political rights, they should have a right to vote, privacy, etc., should, as I said, in principle be applied to prisoners to the maximum extent possible. So perhaps this also relates to questions you would like to raise about prison conditions in general. I think we could bring that in here and then try to get some explanation by you also what you meant with paragraph 81. Please.
Well, just to mention something specific about the sentence that Professor Nowak called our attention to, I think that sentence is ludicrous. It's irresponsible both ways. He's already pointed out the reflection, the negative reflection it gives to the rights of people who've been convicted. But when I read this description of the rights enjoyed by detained suspects, it's ridiculous. It doesn't seem to correspond in any way to the reality I know about in Taiwan or in many countries. It's, I don't know, it's kind of a fairy tale. Secondly, we've touched on Article 7, and Article 10 mentions again the question of degrading status of people who are confined. Inhuman and degrading treatment violates this ICCPR, it's clear. I mentioned 2 days ago that whatever one says about the case of former President Chen Shui-bian, it has focused the searchlight on the conditions in prison cells. The newspapers exaggerated what I said, apparently. I had nothing to do at that point. I said nothing about the judicial process relating to his convictions. I'm only talking about so far the prison conditions, not just for him, but for everybody. And his case showed that the conditions in his cell before the government started to respond to criticisms, and they gradually have improved it and taken him out of the cell. Now he's in a very nice veterans hospital. But the prison conditions certainly are degrading. They certainly are inhuman. Whether you talk about the sleeping conditions or the toilet arrangements or the original arrangements for writing, you wouldn't want to treat any human being to that. So I want to make that clear, that I visited a number of your prisons. I've seen some good ones, even many, many years ago. And I've seen some others that are more reflective, I think, of the general conditions. So I think the detained people do not have such a beautiful life as this sentence would suggest before conviction. And as we'll say later, maybe, it certainly affects any possibility of making a credible defense. Finally, I want to say something here about that's very commendable. You have ended the so-called Liumang Tiaoli. In January 2009, your legislature and your president abolished the administrative detention that was comparable to Laodong Jiaoyang, re-education through labor on the mainland. The mainland, as you know, is struggling now what to do with this. And we're all waiting. This afternoon, the Washington Post is going to interview me about what are the prospects for improving re-education through labor, the ability of the police to put people away with no court review in confinement circumstances that are not beautiful. But you people abolished this. When I first came here in 1961, Guanxuan was a very feared administrative sanction, and the conditions of confinement were terrible for people very often. And over a period of decades, you have abolished that, and that's a great achievement in a Chinese political legal culture and any authoritarian culture. But now we're turning to this question, and that sentence just offended me, because I think we have to deal with reality if we're going to continue to see social, political, humane progress here.
Thank you. Who would like to respond to this general issue? Please, you have the floor.
Good morning. The Detention Act is a basic law for the treatment of detained accused. This law was promulgated in 1946. More than 50-year-old, this law has never been amended. Of course, during this period of time, a lot of things have changed. As Professor Cohen just told us, we are aware of these drastic changes in the world. So we too feel that more work needs to be done to safeguard the human rights of the detainees. So we actually place top priority to the revision of the Detention Act and the Prison Act. Moreover, for a detained person, we follow the presumption of innocence. So in the new Detention Act, we are definitely following the presumption of innocence. The human rights enjoyed by the detained person will be the same as all nationals of this country. Again, it doesn't matter if you are a detained, accused, defendant, or an inmate. The right to use cultural resources, economic and political rights, information right, privacy right, belief, the rights should all be safeguarded. The old Detention Act, of course, is very arcane in many of its provisions. Especially many of the provisions of the Prison Act are applicable under the existing Detention Act, which I believe runs counter to the trend of human rights protection. The Judicial Yuan in December 2008 released an interpretation saying that Article 6 of the Detention Act prohibits the detained defendants from seeking administrative remedy. That particular provision is a violation of the human rights of the defendant. So a comprehensive review has to be done. Indeed, for many times, we invited scholars, experts, and people from different quarters of society to seek their advice on the revision to the Detention Act. There are a few points that I would like to bring to your attention. First of all, the presumption of innocence. This is the basic idea we adopt. Secondly, the detention operations. Usually, right now, the defendant will be able to express his free will on this matter. The revision also touches upon the living conditions, such as the access to hot water and to the barber's services. Not to mention, none of these detained defendants may be forced to receive medical experimentation. As for the right to visitation and receive consultation, the revision have also touched upon these matters. Another important point is the right to correspondence. In principle, the prison officer may have the right to check if any contraband is included in these letters. Otherwise, the content of these letters must not be reviewed by the officers. In the past, when the defendant or inmate talked to his attorney or wrote to his attorney, the officer had the right to check the content or oversee such conversation, but the revision has proposed to change all this. In July 2010, this revision draft was submitted to the Legislative Yuan. Right now, it is under review by the legislators. As for the Prison Act, by the end of June this year, the MOJ would like to propose another revision draft to the Prison Act to the Executive Yuan. So we are aware of the deficiencies in these two laws. That's why we are reviewing and revising them right now.
I would like to add that we use Detention Act on pre-trial defendants, and after prisoners are convicted, that Prison Act becomes applicable. So there are two acts. We know that there's a minimum treatment for pre-trial detainees and post-conviction prisoners at the UN standards. We understand that. And the Detention Act, Article 38, applies mutatis mutandis of Prison Act. Yes, indeed, as Professor Cohen mentioned, dozens of years ago, we didn't have enough understanding in that regard, and there are some provisions that are in violation with human rights standards. So about 2 years ago, we started the review process of domestic laws and regulations based on the two covenants. And in 2010, the draft revision of the Detention Act was submitted to the Legislative Yuan. But we also discovered the need to revise the Detention Act after we signed the ICCPR. And it was already decided by MOJ that when the Detention Act, Article 38, is in favor of the defendant, then it can apply the Prison Act. If not, then it does not apply mutatis mutandis Prison Act. So now we have the administrative measures to limit the use of Detention Act and Prison Act. Thank you very much.
This information, and also for the plans of the government of Taiwan to amend both the Detention Act for pre-trial detainees and the Prison Act for convicted prisoners. Under international law, of course, the most important provision is Article 10 of the Covenant on Civil and Political Rights, which also includes that the main aim of a correctional institution should be the rehabilitation and re-socialization of convicted prisoners. But of course, the Crime Congress and the Commission on Crime Prevention and Criminal Justice of the United Nations have developed all kind of soft law standards, from the standard minimum rules for the protection of prisoners to the body of principles and many others that might be taken into account when you draft a modern Detention and Prison Act, and we are looking forward very much to see the outcome of these legislative endeavors. And as I said, so kind of one of the main principles would be what we call the principle of normalization, so that in principle detainees and prisoners should keep all human rights as far as this is possible and compatible, of course, with the specific security requirements in a closed institution. I personally have no further questions in relation to Articles 7 and 10. I think the answers to our questions 32 and 33 are for me fully satisfactory. If my colleagues have no further questions, then I would move on to Article 8. And again, I think the first question, 34, seems to be also a little bit based on a translation error, perhaps, which was pointed out in the reply, alternative reply from Attorney Su Xiaolun, so that the word hard labor seems not to conform to what under international law hard labor means. So I do understand that the labor imposed if a person who is sentenced to a fine cannot pay the fine is simply another form of imprisonment implementation. And if this interpretation is correct, then it doesn't raise really an issue of hard labor under Article 8. Which brings me to paragraph 35, and that is of course an issue where again you provide information that the new law is in force since January 2013, which does in principle limit the work of student apprentices to 8 hours a day unless there are certain exceptions as stated in paragraph 94, where 12 hours per day could still be required. We have heard also this morning an intervention by a non-governmental organization which still expressed quite severe concerns about this whole business education cooperation project, and the shadow report refers to student apprentices as slave labor. So perhaps we could have still some further explanations by the government to what extent this problem will be further addressed in addition to the recent legislative reforms.
I'm from MOE. Indeed, in 2013, we have the Cooperative Education in High Schools and Co-op Students' Right Protection Law. And you mentioned that some students may involve in special industries and some may have to work over than 12 hours a day. But the Chapter 4 in our protection law stipulates that each student must not be trained or cannot work over 8 hours, and from 10 p.m. to 6 a.m. on the other day, they shall not work. If the administrative agencies spot any violations, we will have some corresponding measures. For example, the presidents of the schools will be subject to administrative punishment, and we continue to encourage the businesses to revise their cooperation project, and it doesn't matter which industry the student apprentice works in. These students will be protected by labor standards law, and since they are also students, the students are protected under education-related laws. And maybe we will be able to submit a more detailed supplementary reply to respond to the shadow report submitted by the NGO.
Thank you very much. I think I would be very grateful for this additional written information, because it's a fairly complex issue. If my colleagues agree, then we could move on. And now we have paragraphs 36 and 37, which both refer to alien workers, migrant workers, and also domestic workers. I mean, this was discussed on the first day when we discussed the core document, and I have been told it is taken up quite extensively in our colleagues' next room on economic, social, and cultural rights, the right to work. So I personally, also having taken note of certain improvements in the Employment Services Act, and also on progress on drafting a Labor Protection Act for domestic workers, I personally would suggest that we are not taking this up anymore and rely on our colleagues in order also to save time and have enough time for Article 14. But of course, if my colleagues would like to raise further issues, I mean, we will come back to migrant workers also in relation to deportation, to Article 13, but not here in relation to the right to work, if this is fine with you. Because then we come already to Article 9. And of course that also relates to some extent to migrant workers, but illegal aliens in general. So that is question 38 in our list of issues. Here my main concern would be in relation to the right to habeas corpus, Article 9.4. If I read from the written reply of the government, paragraph 105, the government admits, it says, as for the writs of habeas corpus, it is not applicable to foreigners or mainlanders placed in NIA shelters. According to the dominating opinion, the writs of habeas corpus is only applicable in detention or arrest for criminal causes. Now, under international law, Article 9.4, the right to habeas corpus is a right that applies to every type of deprivation of personal liberty. So in my opinion, there seems to be a major problem in the implementation of the covenant. So perhaps, I don't know whether my colleagues would like to add something before we get your reply, how you wish to address this problem, please.
I am glad to see in the government's response the description of the very recent interpretation by the Constitutional Court, the Da Faguan Hui, which is another very significant action. I think one of Taiwan's greatest contributions to the rule of law has been the activation of the Constitutional Court, which was for a long time moribund, not active. But in recent decades, it has become a proud product of your democratic achievement. And here, once again, it comes to the rescue with the reasoning similar to that Professor Nowak has just explicated. And I think the answer that it should only apply, habeas corpus should only apply to cases that are called criminal, is totally unrealistic. We have to think things, not labels. In the mainland of China, they say, oh, we can do this or do that to people because we don't call it criminal, even though we treat them like criminals. And here, when you take away people's liberty, whatever label you use, you have to provide a corresponding remedy. And I think it's a logical development, and so does your constitutional court apparently, to extend habeas corpus to any detention by government authority, so people have an opportunity in a reasonable time to challenge it. And I think your constitutional court's recent interpretation takes account of the special circumstances involved here and recognizes that not every form of detention is the same. But the principle should be, and the practice should be, that there is some judicial review, and the assumption is in a country where the judicial review is independent, not under government control or party control. So I'm glad to see this recent decision, and I hope your other forms of administrative detention that still remain, whether for medical reasons or mental health reasons or for other treatment of aliens, that these will all follow that principle.
If I may still add, as Professor Cohen has said, of course, we are extremely happy about this recent interpretation number 708 of 6 February 2013 of the Grand Justices. But for me, it's still a little bit unclear what does that mean presently. What is now applied, because you say at the end, following the issuance of this interpretation, the immigration law and relevant regulations will be amended accordingly to meet the standard of Article 9, 3, and 4. So this is still in the process, but what is presently, since the covenant in principle applies, and also the decision of the Judicial Yuan does apply. So presently is Article 38 of the immigration law still applied in practice? That is my main question. Please.
But I should note that on previous occasions, when the Constitutional Court says to the legislature and the executive, we'll give you 2 years to correct the situation, it happens. Within 2 years, action is taken. So I realize there's this awkward interim of 2 years, possibly. I hope it won't be that long. But you have a good record of responding to the court's device of giving the democratically constituted agencies time to improve the situation.
Well, as we are working on amending the immigration law, we referenced other countries' law in this regard. Most countries do not have provisions about getting a court order before the placement of aliens. So we decided that we would like to stipulate clearly that no longer than 4 months of placement or detention will be allowed. As for the Judicial Yuan interpretation 708, for temporary placement within 15 days, it is allowed. However, in the event of objection by the detainee, the court will have to review the case right away. If the placement is longer than 15 days, the court will have to review this case. So yes, indeed, we have 2 years of time to review and amend existing regulations. So we are working closely with the Judicial Yuan and the MOJ to complete this task within time. Thank you for your attention. I would like to say a few remarks. In terms of the placement of aliens, there are still habeas corpus procedures available. They are the Administrative Appeal Act and the Code of Administrative Procedures. Of course, the Judicial Yuan Interpretation 708 said clearly that a judicial decision will have to be sought, and we will definitely work along the line. As for the application of these placement rules to criminals only, well, maybe the Judicial Yuan could explain. Right now, the Judicial Yuan has a task force to look into the amendment of this law. So there will not be application only to criminal cases. It will be also applicable to administrative cases. In fact, the judicial interpretation indeed said that this amendment has to be completed within 2 years.
Constitution of Taiwan that when the Judicial Yuan is finding that the provision is unconstitutional, that you have 2 years to repair. At the same time, it is a continuing violation of Article 9.4 of the Covenant, which, as we have been heard, is directly applicable at the level above ordinary law, so between ordinary law and the Constitution. So, in other words, it is my understanding that Article 38 of the immigration law is actually derogated by Article 9.4. So in principle, also during the period until the immigration law will be amended, still courts should be empowered, should have the right to decide within the period, and that is a very short period, about any complaints by aliens who complain against their detention order under Article 38 of the Immigration Act. Is my interpretation correct, and will this be also done now in this transitional period, that courts have the power to review the legality of the detention?
In fact, right now there are no such provisions in the immigration law. So judges or courts will have to follow the rule of law. So we still have to wait for the amendment to be completed. I'm sure the amendment will be completed as soon as possible. The Article 9, Paragraph 4 is really about the habeas corpus. So the relevant amendment still has to be completed.
Your response to what Professor Nowak says shows that there's still some misunderstanding about the place of the covenants in Taiwan's legal system. Your response is, once the amendments are made, then we'll all follow them. But what he's pointing out is the covenant exists today. You shouldn't be waiting. You may need details in legislation on how to handle this detail or that. But if indeed this covenant is higher than legislation, you're supposed to follow it now, even though you have to follow what the interpretation of the court says about coming up with detailed rules. So it's interesting. This is a theoretical problem that has some real practical significance, at least for judges, and it suggests there's a gap so far between those who administer the law here and the change in your whole legal system that you haven't yet absorbed. That raises some very interesting practical questions. If I were a judge not on the Constitutional Court, I would implement what the covenant says now, instead of saying, oh, I have to wait for as long as 2 years to see the details. This is a profound question. You're in the process of legal change where theory affects practice.
And of course, it's the Implementation Act that has made the covenant directly applicable. I have Professor Ando.
Yeah, just to endorse what these two gentlemen said, I asked about the ranking of the covenant in Taiwanese domestic code, and also in particular about Article 4 about non-derogable rights. So therefore, they should act under that presumption or under that theory. Yeah. So Executive Diwan should follow what you explained to us. Thank you.
Thank you very much.
But I think there needs to be a clarification, and if somebody in the Ministry of Law could do it. My understanding about the implementation law is that the covenants are not supra-law, but that this is my understanding of reading it, that they are not supra-law, but they get implemented by the legislature and by the judiciary, and once that is done, then the executive branch puts it into operation. This is my understanding of reading that law. And yesterday I had a good look at it. So I think the impression that somehow we were given earlier was as though this is a supra-law, this has been taken as over and above all legislation and constitution, and that we just need to implement it. In my view, as I read it, and therefore I need that clarification, is that these are the standards, and these standards should be implemented through the various organs of the state into the Taiwanese society. So therefore, you are in the stage of implementation, if I may say so, rather than enforcement stage. And the enforcement stage will come after the implementation stage. Now, this is how I read it. And so I want to know which is the correct position and how the government is taking it, how have the Constitutional Court interpreted it, particularly because I don't have the judgment on the detention case, because that should have addressed this question. So how has that been addressed? Because that is very fundamental to what we are going to say here.
我先说明一下，这个我们台湾现在对于
After incorporating the international covenants in domestic laws, Taiwan has to yet decide the status of these international covenants. This has to do with the monoism or dualism of the international law. I think right now we think that it is below the Constitution but above the general law. And you heard cases where the administrative court decisions citing provisions of the covenants. If there are specific legal provisions contrary to the covenant, does that mean right now we can say these provisions no longer apply? In fact, right now there's still debate going on. So on this particular case, the Judicial Yuan interpretation is as valid as constitutional provisions, and each Judicial Yuan interpretation is valid for at least 2 years. So can we simply rely on the Judicial Yuan interpretation to pronounce an existing provision unconstitutional? I think now we are at the infancy stage of incorporating international law into domestic laws. So we are still waiting for more specific instructions from grand justices in this area.
I find that this is a very crucial and a very delicate moment for you. My next question is that to be able to get this implementation in the right direction, do you have well-versed constitutional lawyers who are equally well-versed in international human rights law? Does that body of expertise exist in the bar associations? Because that is going to be very important of which direction you take.
This is a new challenge. I can assure you that Taiwan has some wonderful constitutional lawyers who have played an important role, some of them eventually as judges of the Constitutional Court, but some who appear as advocates assisting the Constitutional Court in its deliberations. What I can't say at this point is how to answer your specific question, because all of this is so new. But perhaps others here can tell us whether the many able constitutional lawyers have already absorbed the international standards that are required now to meet the new challenge.
I think we...
The point of Mrs. Asma, if I may, Jahangir. Now, this is the issue of the, system you consider you adapting. What she's saying is, it's Article 4 of the Covenant is non-self-executing. To me, it is self-executing. It is very clear. So the moment you adopt it, you have to implement it.
That was exactly what I just wanted to say. I think my understanding is, via the Implementation Act, the covenant has been incorporated fully into the domestic legal system, at a level between the Constitution and ordinary law. And of course, primarily that means that the government and parliament need to adjust their laws in a way that they can be directly implemented by administrative agencies and courts. But if there is a contradiction, and in here we have a contradiction between Article 38 of the Immigration Act and Article 9.4 of the Covenant. If the Covenant is self-executing, it has precedence because it's higher. And it reads, anyone who is deprived of his liberty by arrest or detention, that includes aliens, shall be entitled to take proceedings before a court in order that that court may decide without delay on the lawfulness of his detention and order his release if detention is not lawful. Courts are existing. So as you have said, if I would be a judge at the court, I would, irrespective of whether the judicial yuan said you have 2 years to repair the Immigration Act, still in between, in the time in between, a court, if an alien wishes to complain against his detention using a writ of habeas corpus, the court can directly apply 9.4 and say, yes, we are of the opinion that your detention is illegal for whatever reasons, and therefore you have to be released. Or say, no, your detention is perfectly lawful under domestic law, and therefore you remain detained. But I think the habeas corpus proceedings can already now be applied. That would be my reading, but we will have to deliberate on this in our concluding observations, and of course the same applies to the government. If you, as earlier, you can apply Article 9.4 as better it is for the rule of law in the country. I'm looking a bit on the watch also, because we still wanted to take up Article 14 before the lunch break. Yes, please.
抱歉，我补充一下，完全赞同。
I 100% agree what you said. The Article 9 in ICCPR has such a stipulation, and I totally agree with it. And I asked my staff to look for some information. And what I discovered is that after the Implementation Act had become effective, there were no cases that invoke this article. I agree what you said, but so far we have not yet seen any cases that invoke Article 9 under ICCPR. The immigration agency will work with the judicial yuan to work for more positive and immediate results.
Also, NGO representatives, following our discussions, I think there is an appeal to the lawyers to actually bring such a case to the courts, and then we will see whether or not the courts would follow our interpretation and directly apply the habeas corpus proceedings.
这个问题的个别的问题的话呢，也许。
Yes, related agencies and the courts will make future decisions on this regard. When it comes to the effect of the covenant after it is incorporated into domestic law, the MOFA and MOJ is now working on the Multilateral Treaty Act, the Provisional Act governing the incorporation of multilateral conventions into domestic laws. And, well, I think Professor Cohen and Professor Ando also have some students in Taiwan. I think we will solicit their opinions as well.
Thank you very much. Can we continue? So, I mean, you are interested in Article 14, but yeah, please.
I just want to say this opens a new field for lawyers in their law practice, that international human rights law increasingly is going to be a very practical subject here. And so we may find, especially in the younger generation, that they will develop the expertise required.
Thank you. I think question 39 has been discussed already, so we take it that under the new provision, the 120 days or 4 months rule applies under any legal circumstances. It does not legally apply to mainland Chinese, but in reality we have been assured that the same time limit of 120 days would also be applied in practice. That brings me to question 4T, which is pretrial detention, and Article 9.3 of the Covenant is very clear that it shall not be the general rule that persons awaiting trial shall be detained in custody. We have been provided with some statistics, that's paragraph 111 of 2012, saying that the approval rate is 42.07% among all detention orders filed by the prosecutors. The NGO report calls these statistics paradoxical, and I would agree with the NGOs, to be frank, because you have 4 different reasons for detaining a person who is accused of a crime. One of that is accusation of a serious crime. But under international law, this alone should not be sufficient. You always need to have also additional reasons, such as risk of flee, risk of destroying evidence, or risk of recommitting a certain offense. And if I read the statistics correctly, then 42% of all detention orders were based exclusively on the fact that the person is accused or has been accused of a serious crime. So you are right when you say not 100% are detained on this one reason alone. There are also 58% who are detained on other reasons as well. But those 42% are too much. There should be 0%. So the point is, of course, if a person is accused of a crime that carries the death penalty, life imprisonment, or more than 5 years, then of course there is a higher probability that the person can be taken into pretrial detention, but only if you also have another reason. It's not automatically that everybody who is accused of a serious crime would constitute a risk that he would flee or recommit, etc. So in that sense, I think that the explanation that we have been given is not in line really with the requirements of Article 9.3. Would you like to respond, or would you like to add something?
Of course, in every system of criminal justice, this is one of the most difficult questions. Who should be confined pending investigation? Recognizing that investigation of complex crimes may take some time. I should say, first of all, I'm aware of the fact that your prosecutors normally do not seek to detain the overwhelming number of people who get picked up by the police, but only the serious crimes. But as Professor Nowak said, when it comes to serious crimes, then there's a high degree of detention with court approval. The factors to be taken into account, to me the most peculiar one, is when there's reference to, well, if we let this person out pending trial, he or she may talk to other defendants. And that seems to be an assumption that's prohibited. It seemed the most natural thing in the world, if I'm accused of a crime involving other people, that my defense is necessarily going to involve understanding what their conduct is. And it's necessary for me and my lawyer to talk to them. So I don't think that's a legitimate criterion to be taken into account, that if the suspect is released, he'll talk to other people involved in the case. Of course, he's not supposed to bribe them. He's not supposed to cook up false testimony. But to say that in principle he shouldn't talk to anybody else in the case seems to me weird. I used to be a federal prosecutor also. Certainly, I expect anyone accused to be free to talk to other people involved in the prosecution, whether they're co-defendants or defendants in another case or witnesses. So there's a different point of view here. There's an assumption, I think, that you talk to them, you're going to be fixing the case, you're going to be agreeing to lie about the case, and it's best to keep you in jail. I think that comes up in the Chen Shui-bian detention, which was so controversial. And it raises a question in the administration of justice here, when you have serious charges against various former officials, what are the criteria for determining why so-and-so may be prosecuted, like President Ma was prosecuted, but didn't go to jail waiting for the 3 acquittals, and why other people do go to jail. So I think there's a great need to revise your detention law after 67 years. I think it might be time. But it's not a simple matter, as we all know.
Thank you. Please.
目前关于
Well, on remand detention in our criminal procedural law, as you said, well, we have JY interpretation 665. It stipulates that remand detention cannot be the only reason, only ground for detention. If there are risks of escape or other factors that you mentioned, then this suspect can be detained. Of course, as you said, co-defendants may speak to each other. However, if there's evidence proving that they will collude or bury the evidence, then these will constitute obstruction of justice. So only when there is evidence that this person is going to obstruct justice will detention be imposed. But of course, every case is different. And in that case, we respect judges. We respect the right of the judges to make his or her own decision. The MOJ would like to supplement. After the 655 interpretation, the MOJ has already notified all the agencies to notify all the prosecutors. If this person is subject to death penalty or life imprisonment, and the prosecutors have to prove that there's enough evidence, sufficient evidence, either facts or reasons, that this person is at the risk of escape. Then the prosecutors have to submit this evidence to the judges at the court to make decisions. And in the revision of criminal procedural law, the elements will be changed. So if the prosecutors believe the defendant is indeed at risk of escape, obliterating, counterfeiting, forging evidence, or colluding and coordinating with accomplices and witnesses, can they ask the judges to detain?
Very well. That already now Article 101 and 101/1 of the Code of Criminal Procedure is applied by means of instruction in a cumulative way, and there is also the idea to amend the Code of Criminal Procedure to bring it in line with Article 9.3. Thank you very much. Then Article 41, again with the Criminal Speedy Trial Act of 2010, some of the excesses in delayed justice have been addressed. Nevertheless, there is still Article 7, which stipulates that the maximum length of a trial is 8 years, which is still a fairly long period for a criminal trial. And what I understand is that one of the bottlenecks, one of the main reasons is that the Supreme Court often sends a case back to the High Court for retrial, and that kind of ping-pong can still go on quite often. And I think, I mean, the most famous case is a person who was for 23 years, I think, before he was then finally sentenced to death last year. So the question is also 8 years in particular, if a person is also in detention during that time, is a very long period. So are there other measures envisaged in order to further speed up the criminal proceedings, in particular by having a certain maximum number that the Supreme Court can send back, or then should not the Supreme Court finally decide itself if the High Courts are not delivering in accordance with the orders of the Supreme Court? So what is envisaged in order to solve this problem of very long trials, please?
I would only add, it's not only a court problem, but it's a prosecutor's problem. How long can prosecutors go on with the investigation? And if the prosecutor decides not to prosecute, how many times can a party that's a complainant seek a re-examination of the question? Is there no limit? Should they be limited to one request? And should there be a time limit for the prosecutor to respond? And how many times can the prosecutor at the high court level send the case back? So it isn't only a court problem, and it isn't only a high court or Supreme Court problem. Every prosecutor knows it's a problem of day-to-day investigation. How long can you keep somebody locked up while investigation goes on endlessly and giving complainants a right to keep asking for reconsideration. And it's also an intolerable problem even if the person is not locked up. The indictment, of course, as you all know, ruins somebody's life. Maybe only, I'm being sarcastic, only for 5 years, 6 years, while this goes on endlessly. Many good people have had their whole careers, their family, their children affected by endless investigation, especially with leaks to the press that damage their reputation. So I think this whole area needs some further clarification. The Speedy Trial Act is very useful, but it's very limited and very complicated. More broadly, you have to consider the whole question of investigation, who are the parties to the investigation, and can you find some ways of placing limits on this, including, is the current situation for approving indictment sufficient? Given the consequences of indictment, should there be some further check on the ability of the prosecutor to indict somebody? And what could that check be? We have in some jurisdictions a grand jury. Often the grand jury is not much protection, but occasionally it is. But are there other ideas within your own particular political, social, legal context that can protect people against promiscuous indictment, an indictment that results in 3 consistent not guilty verdicts at 3 levels of the courts? You have to ask, was that a proper indictment? Even for people who aren't locked up during the period of the trials, etc. And I think you have a problem at the higher levels also of even now you've limited the circumstances for a prosecutor to appeal, going to the Supreme Court level. Should those circumstances be narrowed further? And of course, going the other way, you have this problem, and we're dealing here with issues that parallel Article 14. They're really together. You have this other problem involving the covenant. If somebody is acquitted in the first instance, convicted in the second instance, mustn't that person be allowed to appeal the conviction to the third instance? Otherwise, there is a violation of the covenant's requirement that you have an opportunity after conviction to appeal. So I recognize this is a complicated thicket, but there are some opportunities here to improve the administration of justice and fairness involving fair trial.
I think Professor Cohen has rightly taken up this combination of Article 9 and 14, which also means questions 41 and 42, so the different extensions of detention pending trial. So perhaps we can take the whole complex together, please.
In response to number question 41, the CW schedule report alleges that there are no clear time limits for court review proceedings. However, that is not true. There are specific time limits. 14 months for the first instance, 2 years for the second instance, and 1 year for the third instance. The Judicial Yuan, in an effort to speed up the trial. In May 2010, proposed the Criminal Speedy Trial Act, which was passed by the Legislative Yuan. In May 2012, it is stipulated that the length of detention, the length of trial shall not exceed 8 years. And for any cases that have been ongoing for over 5 years, you can hardly find any one case of that nature today. So in May 2012, even by then, you could not find a case which had been ongoing for over 5 years. As you said, Professor Cohen, why were there delays in the process? Was it because the Supreme Court kept reverting the cases to the lower courts? Actually, only 10% of these cases at the Supreme Court were reverted back to the lower courts. In the past, this percentage was as high as 45 to 50%. Of course, the reason for such a decision on the part of the Supreme Court was mainly because there was some failure in the fact-finding stage in prior trials. So the Judicial Yuan is also working on amendment to the organization of the Grand Justice Constitutional Court. And if these amendments can be passed, I'm sure the percentage of cases sent back to the lower courts will drop further. We are also trying to help prosecutors to shorten the length of investigation. For example, the president of each court would send more assistance to the prosecutors who have long-standing cases at hand. The same goes for really complicated cases which may need more staffing. Therefore, we have taken different steps to remove the bottlenecks in the system. In response to the question proposed by Professor Cohen, if the charge was dropped, are there any restrictions on the number of the cases being appealed by the prosecutors? Right now, there are no such restrictions, but we are looking into the possibility of imposing such a limitation. And I would also like to report to you that the MOJ has specific requirements of prosecutors. After the case was reverted from the second instance, the prosecutors during the first instance would investigate based on the instructions specifically given by the prosecutors in the second instance. Hopefully, this will shorten the overall time needed. And we also ask the prosecutor that upon receiving the decision has to go back to review the process of investigation and indictment to see if there were any deficiencies or shortcomings so that the prosecutor can decide whether an appeal is in order. No delay is allowed in at this point. So if non-guilty verdict is reached during the first and second instance, and after the said review process, no deficiencies were found, then the prosecutor could write a report to the chief prosecutor explaining the situation and refrain from filing for appeals. So these are a few steps we have in place. As for the investigation right of the prosecutors, according to the Code of Criminal Procedure, there are some restrictions as to under what circumstances a case can be reinitiated. So if a retrial can be applied, right now there are no limits on the number of times the retrial application can be filed. We do have limitation that if the same prosecutor wants to have a retrial back in the first instance, then the whole process will have to be taken care of by the same prosecutor himself or herself. And of course, if more administrative assistance can be offered to the prosecutor, we will do our very best. However, we also have an administrative oversight system to make sure that prosecutors do not procrastinate on fulfilling their duties. So we do have the performance evaluation system.